webinar offered by the Fidelity National Title Insurance Group. I'm Lisa Lugauskas of the Fidelity National Title Group, and I'll be introducing our presenter, Ed Rosenblatt, in just a few minutes. First, a few housekeeping details. You'll all be in listen-only mode during the webinar because we have a very large audience today. If you have any questions throughout the presentation, please type them in the question section of the toolbar. It's on the right-hand side of your screen. We'll answer questions throughout the presentation as well as at the very end of the presentation, but again, we do have a very large group today, so the number of questions our speaker will be able to address will be limited. We hope to complete the webinar right on time at 11:30. And now I'll introduce our speaker, Attorney Ed Rosenblatt. Ed is a Vice President and Counsel at the Fidelity National Title Insurance Group. He has extensive private practice experience as well as title insurance experience. He was a past chair of the Executive Committee of the Real Property section of the Connecticut Bar Association, and he's been on the Executive Committee since 1987. Ed is currently the chair of the Residential Real Estate Certification Committee and co-chair of the section's Legislative Committee. He's a frequent lecturer on real estate and title matters. Ed, let's begin.
Good morning, everyone. This is Ed Rosenblatt. Welcome to all of you to our webinar on the Connecticut Uniform Power of Attorney Act. I'd like to get started and move through the material rather quickly. This is a very extensive act that makes lots of important changes to how we will work with powers of attorney starting on its effective date, which is coming up on October 1st. So because this is only a 1-hour webinar, it will be impossible for me to cover every important point and every change that this act makes, but I will hit on the most important points and the most important things that you need to know. As Lisa graciously pointed out, you will be able to type in questions on your control panel, which you should see on your screen at this point. But because there are so many participants, at this moment, there are more than 130 people signed on to this webinar, and we expect more over the next few minutes. It will probably be impossible for me to answer every question that gets asked. So I'll try my best to hit most of them and give you as much information as I can. And of course, I'll be available after the webinar to discuss any other issues that you might have. So let's get started. We are going to talk about the new act, which was created really by 2 acts of our legislature. The first was the enactment and the adoption of the Uniform Power of Attorney Act, and then that was by Public Act 15240. And then a second act made revisions to the initial act, and that was at Public Act 1640. And as revised, this act is now contained in the 2016 supplement to the Connecticut General Statute and will be located at Section 1-350 and following of our Connecticut General Statutes. As I mentioned, the effective date is October 1st, 2016. So this will apply to all powers of attorney that are executed on or after that date. We're going to be talking a little bit today about the content of the statute and also the 2 forms that the statute recommends, the new long form and the new short form power of attorney. And I'll talk a little bit about the difference between them. All of you who are attending this webinar today will receive by email copies of these forms, together with a couple of other useful forms, and together with a copy of the PowerPoint presentation that you're watching today. In addition to that, this presentation will be recorded and will be available for later view, and we'll be sending you all links to where you can see the recording on the website. Again, this new act is contained now in the 2016 supplement to the Connecticut General Statute. It has not yet been published in the normal full statute books, so you won't find them there yet. This next page is simply an index of where some of the important provisions of the Act are located. And you can use this slide as a reference, but it's primarily at Section 1, 350 and following statutes. A few general provisions. First, there's a new definition. This new act no longer refers to attorneys in fact, but rather agents. So someone is no longer, as of October 1st, appointed to be an attorney in fact. They are appointed to be the agent of the principal. And we're going to use the word agent from now on instead of attorney in fact. How about applicability? The new act applies to all powers of attorney except for the ones you see on this list. Powers to creditors, those are the kind of powers that are normally contained in both consumer and commercial loan documents. Healthcare decisions, a proxy for an entity, a business entity such as a corporation or an LLC, and governmental and military forms of powers. Those are all accepted from the provisions of the new Act. The new Act applies to powers executed before, on, or after October 1st, 2016. It does not mean that powers executed before October 1st are no longer of any effect, or that the new forms must be used on or after October 1st. Any power that's executed prior to October 1st is still valid and still will be recognized under law and the new Act as long as it was validly executed under the current law at the time of its execution. This is a very important change in the Act. Under current power of attorney law, powers must state that they are durable in order to be durable, in order to survive the incapacity of the principal. Under the new Act, making a statement of durability is no longer required. Every power of attorney executed on or after October 1st is deemed to be a durable power of attorney unless it explicitly states that it will terminate upon the incapacity of the principal. So if you want a power not to be durable, you must explicitly state so if your power will be executed on or after October 1st. That is an important reversal of existing law. The method of execution of powers is also affected by the new Act. First, as always, powers must be signed by the principal and dated. But the new Act provides that the power may actually be executed by a person other than the principal. It may be signed by another person, executed in the presence of the principal, and directed to be signed on behalf of the principal. So that means that a person who is physically disabled but would like to appoint a person to be their agent may direct another person to execute the power on their behalf. Notice the slide states except for real estate. There are several provisions of the Act, several permissive provisions that will not apply to powers that are to be used for real estate transactions, and I will summarize those later in the presentation. Powers, as before, must be witnessed by 2 witnesses if executed in Connecticut. That's not a change in the law. But one other important change in the law is that acknowledgments are no longer required for powers of attorney. Notice, again, the exception for powers executed for use in real estate transactions. So an unacknowledged power of attorney is still valid in Connecticut if executed after October 1st. There is a presumption of validity if there is an acknowledgement. So you take a little bit of a risk by having a power without an acknowledgement because it does not have an automatic presumption of validity, but it is not rendered invalid by the failure to contain an acknowledgement. Third parties are required to accept powers that are executed even though they may not be acknowledged. And we're going to get into a little bit more detail on the third-party requirements, third-party acceptance requirements of powers as we go through the slides. I've tried on these slides to refer to specific provisions of the new act that deal with the issues that I'm mentioning. So the execution provisions of the new act are contained in section 1-350B. A power of attorney may designate the governing law. Therefore, a power executed in Connecticut may designate that it is intended to be interpreted under the law of a different jurisdiction. So a person who has assets or other property in other states who wishes that to be disposed of or dealt with under the law of another state may so designate in the power. If no designation is made in the power, then the law of the state in which the power was executed will prevail. Another new provision of the Act permits the designation of a conservator for future incapacity. That means that the power may state a designated conservator that the principal wishes to have named in the event that there is an incapacity in the future. And that designation, as set forth in the power, will be recognized by courts unless the person who's designated is either unable or unwilling to serve, or there is evidence provided of their inability to qualify, or that they have performed some bad act, or that there's some reason that they should not be qualified. And I see a question posted here. I'm having a hard time reading it right now, so I will get to that later on. Let's go to the next slide. When a conservator is appointed or designated, the power of attorney is not necessarily terminated by the appointment of a conservator. That's another important change in this act, that at the time of incapacity, a judge must make a ruling as to whether the power will continue, will terminate, will be temporarily suspended, or will be limited to certain powers. So it's altogether possible for powers that are executed on or after October 1st that there will be both an agent, formerly known as attorney-in-fact, and a conservator with powers simultaneously. That's going to be up to the judge to make that decision. And the judge will be bound, if the judge is made aware of the fact that there is a power of attorney in effect, a ruling as to whether that power of attorney will be terminated, will continue in full force, will be suspended, or will be limited. In the event that the power of attorney is permitted by the court to continue in any capacity, then the agent is accountable to both the principal and the conservator. And if the court orders anything other than a complete termination of the power at the time of incapacity, the power will be automatically reinstated to full effect if and when the principal is restored to full capacity. That is set forth in Section 350G of the statutes. Another change is that the power of attorney is not impacted or voided due to the passage of time. Now, under existing law, prior to October 1st, there is no statement in the statute about the length of time of the validity of a power. But the new act specifically states that the passage of time does not impact or void a power due to its age. What does terminate a power are the factors that you can see on this screen: the death of the principal or the principal's revocation of the power, the death of the agent or the incapacity or resignation of the agent when there is no successor provided. And as I specified earlier, a court order of termination under 1350G, that is, if the principal is found to be incompetent and the court orders its termination. Another change: a subsequent power of attorney does not automatically revoke an earlier power unless the subsequent power specifically provides so. Therefore, the appointment of a second agent by a second document would create a situation in which both of the named agents remain agents and both of their powers remain in effect. So a good practice may be, when writing a power of attorney for a client, that it contains a provision revoking prior powers.
Ed, can I jump in with a question from Jessica?
Sure.
Her question was, if a third party signs at the direction of the principal, do they sign the principal's name by that person, or do they sign their own name?
The statute does not answer that question. But I presume, in reading the statute, that the person would sign their own name as instructed by the principal. And of course, if the power is going to be acknowledged, then this is going to change the way the acknowledgement reads as well. Because the person who will be giving the acknowledgement will be the person signing the power, not the principal. So there's no statutory provision for the language that must be set forth in the acknowledgement when a designated other person executes the power. But I imagine, and I expect, that the acknowledgement will be something to the effect of, personally appeared before me John Smith, who signed this power of attorney on behalf of William Jones at his or her direction, and acknowledged the same to be his or free act and deed, and the free act and deed of the principal. It's going to be something like that. But we don't really know, because the statute does not provide what an acknowledgement will look like under those circumstances. The statutes also provide for relief for those aggrieved by the acts of an agent. The first is an accounting, which is existing law in Section 45A 175. That section has not changed. But the new act provides its own provisions for relief, which would include asking a court to construe the terms of a power, asking a court to review the agent's conduct, and in the event that the court deems the agent to have acted inappropriately or be guilty of misconduct, to grant appropriate relief. Let's talk about the acknowledgement issue again. First, acknowledgement, as I mentioned before, are not required in order for a power to be valid. Second, there is a presumption of genuineness of a principal signature, even without an acknowledgement. A third party accepting an unacknowledged power may rely upon it in good faith. However, a third party will have the right to ask for additional substantiation of the validity of the power. First, the third party may request the agent to certify as to any factual matter concerning the power. Second, if the power is not written in English, they may request an English translation before being obligated to accept the power. Third, a third party may request the opinion of counsel as to any matter of law pertaining to the power. These are all things that a third party may request before being bound to accept the power. That request must be made within 7 days of being presented with the power. If 7 days pass and none of those items of substantiation are requested, then the third party will be bound to accept the power. The third party may not require that a different form of power be utilized before accepting it. Under what circumstances may a third party refuse to accept a power? First, if a request made within that 7-day period is refused or not honored. Second, if the third party in good faith believes that the power is not legally valid for some reason, or that there is no authority for it. That cannot be done simply because there's no acknowledgement. Or if the third party has actual knowledge of a complaint on file by the Department of Social Services. In the event of a dispute as to the acceptability of a power, the probate court or the superior court may order acceptance. And if a third party challenges the validity, and it does go before the probate court or the superior court, the prevailing party in that action may be entitled to attorney's fees and costs. And this puts a strong incentive in place for the acceptance of powers, because the refusal to accept the power may result in a probate court or superior court legal action, which could result in both an order to accept and an order to pay attorney's fees and costs. Another change from existing law is that the current act states that a photocopy of a power must be accepted just as well as an original power. This is another exception for when real estate, when the power is used for real estate transactions, because under Connecticut law, only original documents may be recorded, and the requirement for recording powers remains in effect.
Ed, excuse me a moment. Another question, maybe a little out of order, and I'm sure you'll address it later, but just to jump in, Lou asked, is a power utilizing the form under the new act valid if executed prior to October 1st?
So the answer to that is there is no reason to believe that using the new form prior to October 1st will invalidate the power. However, since the new act goes into effect on October 1st, a power executed prior to October 1st, regardless of what form is used, will not be valid without an acknowledgement and will not be valid unless it's actually signed by the principal. Those two provisions take effect on October 1st, and prior law will control them if the power is executed prior to October 1st. So the form itself will not necessarily be invalid or unacceptable, but the provisions of law dealing with execution apply depending on the date of execution. So powers executed prior to October 1st must be acknowledged and must be actually executed by the principal, regardless of which form is used. Under the new act, there are two sets of powers that can be allocated to an agent. The first are known as standard powers, and those are the same kind of powers that we have typically seen in our powers of attorney up to this point. They may be incorporated by reference in the power rather than specifically listed, so that a power of attorney may, by reference to the statute, sections 351C to 351P, may incorporate all of those standard powers without enumerating them separately. Those include the normal kind of powers that we've seen in powers of attorney prior to adoption of this act, including, by example, powers to do real estate transactions, powers to deal with stocks and bonds, powers to deal with banks and other financial institutions. But there are some powers that are known as the hot powers. That's the second group of powers. They've been referred to as hot powers. Those powers cannot be incorporated in the power of attorney by statutory reference, but must be expressly granted in the instrument. And those include the creation or amendment or revocation of a trust, the making of any gift, the change of a beneficiary designation, and the disclaimer of property. Unless those powers are expressly granted in the instrument, the agent will not have those powers. And unlike the current form of power, where powers must be crossed off in order not to have them, or initialed, the hot powers must be initialed in the form of the power that's executed in order to grant them to the agent. There are two forms of powers that are set forth in the Act, the short form and the long form. The main difference between those two forms is that hot powers, the powers that must be specifically granted and designated in the power, are not set forth in the short form. They are only set forth in the long form. So if you're preparing a power for a client and you want to include any of the hot powers that are set forth in the new act, you will need to use the long form, and if you use the short form, you will not have those powers granted to the agent. Keep in mind that the two forms that are set forth in the statute, the short form and the long form, are only recommendations. The Act does not bar the use of other forms, and the Act specifically states in Section 1352 that it does not bar the use of other forms. So you are free to custom make your own form. Note that both of the recommended forms, the long and short form, contain acknowledgments in them, even though the acknowledgment of a power is not required.
Ed, we have another question. Does the opinion of counsel have to be someone other than the attorney who took the acknowledgement? And before you answer that, for those of you who jumped onto this webinar a little bit later, if you have questions, go ahead and type them in to the right of your screen, and we'll try to answer as many as possible. But it is a large audience, so we can only address a few.
I'm not
sure
I'll be able to answer all of them.
Okay, right. So about the opinion of
counsel. There is no requirement in the Act that the attorney who took an acknowledgement or acted as a witness even in a power be disqualified from giving an opinion on that power. So it need not be a different attorney. I see another question here asking, can third parties in another state refuse to accept the new power, or is this a more uniform national power of attorney? The answer to that is a little bit complicated because this is a Connecticut Act, and the jurisdiction of this act is limited to Connecticut. So I can't see how a third party in another state would be bound to accept a power that complies with this act. Unfortunately, it's not that simple, though, because what we have adopted in Connecticut is a uniform act, which means that there are quite a number of other states, I believe over 20 at this point, that have adopted this uniform act, of course, each with slightly modified provisions, just as Connecticut has already made some modifications to the provisions of the Act here in Connecticut. I'm sure that the other states that have adopted the Act have made their own modifications to it. Nevertheless, it is a uniform Act. So I would suppose that in another state which has adopted the Act, that third parties in those states would be required to accept powers just as third parties in Connecticut would be, under the same rules that third parties in Connecticut would be required to accept powers in Connecticut, because the statutory provisions in that state would be the same. Let's talk a little bit about designation of more than one agent in a power executed on or after October 1st. A principal may designate more than one agent, just as a principal may do that prior to the effective date of the new Act. However, there is a provision in the Act that states that the power of co-agents is deemed to be joint rather than several unless the power designates otherwise. Therefore, if you see a power of attorney executed after October 1st in Connecticut, and it names more than one agent and does not state that their power is several, you must get the signatures of all the agents in order to have an effective document. The Act states that they are jointly powered rather than severally powered, unless the specific power designates otherwise. As is also in effect under current law, a principal may designate a successor in the event of the resignation, incapacity, or death of a primary agent. The Act also states that co-agents are not liable for each other's acts, but it does impose an affirmative duty on any co-agent to inform the principal of any wrongdoing by a co-agent if they have actual knowledge of wrongdoing. That's an affirmative duty that this new act imposes on co-agents. Section 350T of the Act states that principles of law and equity supplement the new Act. That means that in deciding cases and controversies concerning powers that are executed after October 1st, general principles of law and equity will give judges very broad discretion. So it takes this act out of the realm of strict construction because of this provision that gives courts the right to apply general principles of law and equity in their decision-making on these powers. Back to our discussion of hot powers. These are the powers that agents may have if they are specifically granted in the powers. And remember, the short form will not contain them. And this is a partial list of some of the hot powers that the Act provides. Creating, amending, and revoking or terminating a trust. Making a gift. Creating or changing rights of survivorship, creating or changing beneficiaries, the right of an agent to delegate authority, the waiver of the right to be a beneficiary, and the exercise of fiduciary powers that a principal already has the right to delegate, and the disclaimer of property, including a power of appointment. These are all hot powers which must be specifically granted in order to delegate them to an agent under any power executed after October 1st.
Ed, I know you mentioned that the Act specifically states that the hot powers must be contained in the long form rather than the short form, but we have a question that asks, can I designate hot powers within the special provisions section of the short form without having them initialed?
You can designate hot powers in any form by adding them into the form you use, but not without having them initialed. A hot power must be initialed in order to have effect, no matter what form you use. So you can start with the short form that doesn't set forth any of the hot powers by default, and you can add hot powers to it, but they will still require initialing.
Can the hot powers, Ed, be initialed by the principal's designee? I think you mentioned that a principal can designate someone to sign the actual power of attorney, do you think the hot powers, if that authority is given to someone else to sign the power, do you think that party can also initial the hot powers in a long form?
That's an excellent question, but it is not specifically addressed in the Act. I would presume that if the Act authorizes a principal to designate a signer, it could also permit a principal to designate an initialer. It just seems to make logical sense, but that may end up being one of the provisions that gets decided by a court or in a revision, a later revision or amendment to the Act. And I think that we've seen and we will see a number of things in this Act that may get resolved by a future amendment to the Act. Section 1351 makes another important change. It states that unless the power specifically provides, an agent other than a family member, and it defines family member as a spouse, an ancestor, or a descendant. Notice that does not include siblings. A spouse, an ancestor, or a descendant may not exercise authority to create an interest in the agent in any of the ways that are listed here. So under current law, a power of attorney or an attorney in fact, rather, now known as an agent, but under current law, an attorney in fact may not give him or herself a gift unless specifically authorized. This section restricts that only to non-family members. Therefore, there is no prohibition against a parent, an ancestor, or a descendant, or a spouse to give him or herself a gift because they constitute a family member. So this broadens the ability of an agent to give him or herself a gift without special designation in the power. The only time you need special provision in the power for a gift is if the agent is not a family member. And this seems really strange to me because most of the cases that we've seen in which gifts have been given by an agent or an attorney, in fact, to him or herself, occur when the agent is already a family member. So I'm suspecting that this may be one of those provisions that is ripe for amendment the next time the legislature looks at this act. But as of October 1st, if the agent is an ancestor, a descendant, or a spouse of the principal, there is no prohibition against self-gifting. Important to keep in mind. Three areas in which some of the changes that we've seen in this act will not apply to powers that are utilized for real estate transactions. First, an unacknowledged power will not be accepted for use in real estate transactions because Connecticut law requires documents utilized for the transfer of interests in real estate to be acknowledged. Second, although the new act provides that a copy is as good as an original power must be submitted for recordation in order to be used for a real estate transaction. That, again, also because Connecticut law requires that original documents be recorded. And third, the provision about designating a third party to execute a document will not be accepted for powers that are used for real estate transactions. Again, because Connecticut law requires that documents used to convey interest in real estate must be executed by the party conveying that interest and not by a designee. So these are three areas where if you're dealing with a real estate transaction, the provisions of the new act will not apply. Acknowledgement, original, and execution by the principal.
Ed, a quick question that probably calls for your opinion from Emily. Talking about acknowledgement for a power of attorney executed prior to October 1st. Those agents, were referred to as attorneys in fact. If that power of attorney was executed prior to October 1st, should that attorney in fact continue signing as attorney in fact, or should they begin to sign as agent?
I think that's more or less a semantic term, but for a power of attorney executed prior to October 1st, it in fact designates the person as their attorney in fact. And therefore, I would continue to use the designation of attorney in fact for powers executed prior to October 1st. What happens, and this is sort of a follow-up question, what happens if a power of attorney executed after October 1st designates the agent as an attorney in fact rather than an agent? I don't think that will invalidate the power. And I think that powers executed after October 1st may designate either an agent or an attorney in fact. But when it comes time for a legal interpretation of that power, then the person will be referred to as an agent. That makes sense? I think so.
Yes, yes.
The general authority with real property. Unless the power provides otherwise, when a power executed after October 1st authorizes an agent to have authority for real property, that power authorizes the agent to do all of the things that are enumerated here: to demand, buy, lease, receive, accept as a gift any interest or right in real property; to sell, exchange, convey, lease, or option property; to pledge or mortgage an interest in property, or to borrow, pay, or renew a debt secured by real property; or to release, assign, pay off a mortgage, enter into a contract, lien, or other claim against real estate. So you can see that by designating authority to deal with real property, and this is not one of the hot powers, this is one of the standard powers that can be incorporated by reference. It need not be, but it may be incorporated by reference. That will give to the agent very broad powers in dealing with real estate interests. And this is not a substantial change from current law. What about existing powers? Powers executed prior to October 1st will continue to be valid if that power complied with the law effective at the time of the execution, which means essentially that it must be executed by the principal and not by a designated person, and must be acknowledged. The power of attorney for health care is effective if executed prior to October 1st as long as it's properly executed. Remember, we discussed at the beginning of this session that the new act exempts health care powers from its provisions, and therefore we must look to other statutes for health care proxies and health care agents and powers of attorney. But a power executed prior to October 1st can still deal with health care decisions. And that is the end of our presentation. We have a few minutes left. If there are any additional questions, I'm looking at the typed in things, and I'm going to try and see if I missed any that I can see here.
There's an interesting question, Ed, regarding powers of attorney signed under the old act. If there is a power of attorney executed prior to October 1 and it's a springing power of attorney, what if that springing event occurs after October 1? Is that old POA still valid?
If the springing event, the date of the springing event is not the controlling date. The controlling date is the date of execution of the power. So that any power executed prior to October 1st, if that power is validly executed pursuant to pre-October 1st law, that its provisions will continue to be valid regardless of when the springing date is.
Another question that was just typed in, how do you know when you can rely on the subsequent agent? How do you know that the primary agent no longer has authority? Does that primary agent need to resign or be removed?
The power of the primary agent goes away under the new law upon either the agent's death, the agent's incapacity, the agent's resignation, or the agent's removal by a court of law. And that is one of the things that a third party may request information on prior to accepting a power. So that if you are a third party and you're presented with a power executed after October 1st, and the agent is a successor agent, you have that 7-day period to request information or even an opinion of counsel as to the validity of that power, which would include the right of the successor agent to act.
Okay, do you see any other questions?
I don't see any other unanswered questions at this point. So I'll just remind people that this presentation is being recorded and will be available for later viewing, listening, and use. And that if you have registered for this presentation, you will receive by email a copy of the PowerPoint presentation that you've seen, together with copies of several forms that are incorporated in the statute, including a copy of both the short form and the long form powers.
And the copies you receive from us will be in Word format, so you can use them after October 1st in your practice. And do you have anything else, Ed?
I think that brings us to a close. So let me say thank you to everyone who's attended. We appreciate your giving your time to this. As you can see, many of the changes of the Act will make the construction and the drafting of powers a different art than it has been up to now. And if anyone has any continuing issues or questions, we're available to answer them for you. So get in touch with us.
Okay, thanks, Ed, and thanks everyone for listening in. We'll be having future webinars on legal topics and title insurance topics, and we hope you sign into those as well. Everyone, have a great first day of fall.